Yeah, this is a extremely urgent matter of a court number 16, my lords. Notice is there, my lords, to mention before this court. This is the examination matter of IIT JEE, my lords. The candidate has appeared in the examination, but when the result came, one question remained unattempted and options of 4 questions changed. It has happened all over India. Recently, one writ petition was filed in the Honorable Delhi High Court, wherein the interim order granted to permit the petitioner to appear in JEE advanced examination scheduled to be held from 18th of May, my lords. So this is the urgency, my lords.
The court is not available for how many days?
Today it is not available.
How do you just mention tomorrow? I just allow your mentioning for tomorrow, but you mentioned there in this thing.
Yes.
Only today the court is not available,
yes,
I suppose?
Yes.
Is it defect free?
No, lords. Today.
No, you removed that.
Saturday only. I filed IA for ignoring the defect. Because Saturday we
what
have.
What is the defect to be ignored?
The defect has not still been pointed out.
And you have filed an IA for ignoring it?
We have filed an IA with a statement that if any defect is pointed out, it may be not seeing the urgency of the matter.
इसका 80 केस का ना स्टैम्प रिपोर्टिंग करवा के खा दीजिए उसके बाद स्टैम्प रिपोर्टिंग करवा ये तो हो ही नहीं पाएगा कल की नहीं ऐसा डिफेक्ट नहीं कर पाएंगे प्रैक्टिकल नहीं हो स्टैम्प रिपोर्टिंग करवा के उसको दिखा दीजिए और इस है ना ये तो नहीं होता जानते हैं ना ऑफिस में से इसके लिख दीजिए इनको अगर डिफेक्ट पॉइंट आउट हो जाता है वो तो हो सकता है
हाँ
ठीक है यू डू इट
यस
उनको परमिशन दे दीजिए कोई दिक्कत नहीं देख लीजिए कोई आइए फाइल करना कुछ भी सप्लीमेंट्री कुछ भी फाइल करना है तो हम इनको अभी से दे दिए परमिशन कि आपका सप्लीमेंट्री ले लेंगे
यस
ठीक है
This is the land acquisition matter that you mentioned last week, the erection of transmission lines.
Yes.
We have received instructions from the state that they will receive instructions today itself. So it will be listed tomorrow. It is listed today in the roster of information listed.
Instructions means what instructions means?
So last week he had taken judgment that.
You have served copy on the other side?
Yes.
Who is for taking
Advocate Ashok Kumar.
No, he was representing only the state.
He received the copy for JBV. He is for JBV and MSME. We have served the copy at the. He asked us to serve the copy at the Advocate General's office. We have served the copy.
So now you have to. You are mentioning it for listing.
It is listed today, madam. But
So, what do you want?
they have failed to take instructions. They are saying that they will receive instructions today, so it may be posted.
Give the slip. Give the slip.
Yes, this is mentioned for Order 416. This is a matter where the MSME Council has passed the award against the petitioner's company, and now, without hearing us, we have never participated in the entire proceeding, and all of a sudden, certificate case has been initiated and warrant has been issued. So this petitioner, so this director petitioner is having a breast cancer, and she is 74 years old.
That
living
is
in
not
Delhi.
an excuse.
No,
for
I'm only
non-payment of
requesting his
anything.
first listing needs to be done before 9th, otherwise my IA will be infructuous because we,
You have wrongly moved the report. You go and file your 34.
MSME Council.
MSME Council, you go and file 34. I will not permit this kind of thing.
It's similar, it's a Code 16 matter, but it's a fresh filing WPC where I am 85-year-old person, I am a owner of land, where without any notice under the 2020 Rehabilitation Act, a road has been constructed over my land. But I already have filed various representations before the
There is no urgency.
From bill list for final disposal item 1, first appeal 118 of 2023.
Are you for the appeal?
Please.
Arising out of a partition suit was dismissed ex parte.
Where is the other side?
They have not appeared here. The last date, an order passed that would be heard without. on the last date.
Last date was the first date after notice.
Yes.
Anyways, what is the matter? Why have the first appeal been dismissed?
The suit has been dismissed already.
Sorry, suit has been dismissed. Right?
Suit has been dismissed.
You don't have a valid cause of action.
That is one of the issues that
That is the only issue.
that I will satisfy that is incorrect appreciation of fact. My actual contention will be around section 33 of the Evidence Act, read with 145 of the Evidence Act. Because the learned court has called for records of another case without satisfying itself as to whether threshold of 33 of Evidence Act was met, number one. And number two, thereafter gone ahead and made a decision on the title of the suit, which I'm not saying is barred in a partition case. As long as it is incidental, a title declaration may be given, but without giving me an opportunity to contest the documents as per 145 of the Evidence Act, where I can either disprove or I have an opportunity to contradict those documents, even though I was a party to that suit from which the records were called for. 145 Evidence Act cannot be given a go by. Section 33 threshold has to be met, and a finding has been returned, even though Jamabandi is running in my favor. Finding has been returned that neither the plaintiff nor the defendant has a title on this suit property. As far as cause of action is concerned, that is in my plaint itself. That is incorrect appreciation of fact.
You have to, what was your cause of action?
My cause of action in para 7 of my plaint, 7 onwards, 7, 8 and 9.
Tell us what was your cause of action?
Cause of action is that plaintiff and defendant had purchased the property together. The property schedule A is 9 kathas and 5.5 chata. I had purchased 7 kathas and the defendant had purchased 2 kathas and 5.5 chata. Thereafter, we had decided, the issue was that he wanted to purchase the property from me, I refused to sell it. And I said that I wanted to be separated. And thereafter he refused, so we filed a partition suit. It is a partition suit between co-purchasers, not ancestral.
So your area was not earmarked.
No. And we were paying rent
Joint
jointly.
purchase.
Yes, joint purchase. But in the recital itself, it is clear that I have paid such as I have purchased 7 kathas, and it is my case that I have purchased 7 kathas. So that is the cause of action.
What about the recital you was reading? Is it 7 cut? It is mentioned that this much will be your share. What was the total area?
9 kathas. 9 kathas and 5.5
As
chata.
per the state deed,
9 kathas. Total area is 9
total
kathas.
area is 9. And how about you?
I have purchased 7 kathas.
Mentioned in the state deed?
Yes. Sale deed has been exhibited also.
Exhibit 1?
1. Original has been exhibited. As well as the deed of rectification, that also original has been exhibited.
Exhibit 1?
Yes.
Exhibit 1 is general power.
No, that is Roman 1.
Yes.
Roman 1. So what has happened in this case that I exhibit some documents, that is exhibit 1 through 4 by A. Thereafter the learned court during course of final arguments asked me to give the power of attorney also, because it was purchased through power of attorney holder, who is husband of this plaintiff, Vijay Shankar. So that was exhibited marked as Roman 1. And the second power of attorney was marked as Roman 2. The other documents that were called from the other title suit are marked Roman 3 onwards. If your ladyship comes to the immune judgment first.
Produced by plaintiff in
Course of final.
suit as well as in appeal. What is this? Produced by plaintiff in suit as well as in
Perhaps your ladyship was on running
number-
page
running
36.
page 20.
Internal page 20 of the
Internal page 20.
Yes, yes. That is
What
that
is
is
it?
the
Produced by plaintiff in suit as well as in appeal.
yes, that
What is this appeal of?
subpara may be seen, that is subpara Y. That is exhibited documents by court in this case from record of TS 139 of 2012. So in that case,
Suo motu.
yes, so it called for these documents after observing that the recital is not clear of the sale deed. Which is why my contention on section 33.
Have you prepared your notes?
Written notes or arguments?
Certainly.
Written notes.
नहीं बनाते हैं at the point of determination you give a suggested point of determination. Why you determine just argument you will decide it. And also your judgments which you are relying upon. आप जैसे बोल रहे हैं ना section 33 ऐसे नहीं चलता है ना. You have to articulate on that. And if you have any decided judgments, you have to bring it to the notice of the
Yes,
court.
I have two judgments, written notes are not good.
So you just, since it is an ex parte proceeding, court has taken extra care. So where the court has went wrong, that you have to specify, and then we will see what is going on. And since that judgment also indicated that there was no cause of action, so I just wanted to know that what was the cause.
That I will satisfy, that is in my plain itself. Cause of action for a partition suit is as soon as there is a dispute with regard to any separation of shares also, as per 54 of the Code of Civil Procedure.
No,
There is a cause of action for a
when the
partition.
when two persons from distinct family
Yes.
are joint
Purchasers.
purchasers,
Yes.
then there cannot be any reason for saying that
There is no cause of action. Yes.
cause of action. Apparently so.
I am not going to, in fairness, I am not going to say that the learned court has incorrectly made certain observations with regard to sale. I'd be the first person to say that yes, there is appears to be some sort of issues in the recital. But that is not an occasion for the learned
So
court to say
you
that
have-
neither plaintiff
you
nor
have two
defendant are
parts.
entitled.
You have two parts. One is certain procedural irregularity, which you need to highlight, and that you need to highlight by referring to the proceeding sheets. That how the court called for the record, was there any petition filed by you? So that is important. How the court proceeded, because the court is calling for records of another court. Was it at your instance?
Not
Or, right, you are saying, but before you say this, you need to go through the audition. Have you seen the audition? Please go through it. And post it on a date and prepare your notes, we will decide it. As it is, they are not appearing. Just immediately after vacation. This side of the vacation, I don't want to reserve any judgment. So, or if you want, this side is difficult now. It is just, we are just running in the last week. So that you can prepare.
week commencing 16.
Yes, why not? Certainly, we commence with 16. And this will be one more opportunity to the respondent to
To
appear,
appear.
in case they want to, because this
Very good.
you will have summer vacation in the meantime. They may appear, and if they still don't appear, then later on they will not have an excuse for not appearing. As it is, the notice was served by hanging. It was not a case where he was personally served. Isn't it?
This will be paper publication.
Paper publication for me.
Suit.
Suit. His wife perhaps refused to accept, and this kind of stories they can discuss. Okay, FA number 118 of 2023. The learned counsel for the appellant is present. Nobody has entered appearance in spite of repeated opportunity. The notice was accepted to have been validly served by the order dated 25/7/2024. And thereafter on 29/8/2024 also, nobody appeared on behalf of the respondent. The matter was ultimately taken up on 19th of February 25 and was posted for final disposal today. The learned counsel for the appellant has commenced his hearing and has submitted that the property involved in this case was jointly purchased by the plaintiff and the defendant, and the suit was filed for declaration of area to the extent 7 kattas over Schedule A property of the plaintiff. They submitted that the learned court has wrongly held that there was no cause of action for the suit. He has also submitted that there has been procedural error in as much as the records from another suit were called for and exhibited before the court, and the provisions of section
33 of the Evidence Act,
33 of the Evidence Act,
read with 145.
read with section 145 of the Evidence Act, has not been followed. and
145. 145 is usually used for contradicting unfavorable witnesses. You earlier referred to as hostile witnesses. But for the purposes of this section 33, it will be relevant because I will have an opportunity to contend whatever documents are being exhibited. It will have to be put to me.
read with section 145 of the Evidence Act.
Despite
And
the
those
fact-
material has been used against the applicant,
Yes.
correct?
Yes.
The learned counsel for the applicant is directed to file short synopsis of arguments and suggested point of determination in this appeal. आराम से बनाना है, ठीक है? Put this case for further hearing on बताइए.
After 16th date.
17th of June, in the supplementary cause list, you are relying upon such judgments.
Yes.
Okay. The learned counsel has referred to the following judgments.
The 1920. May I just pass it on? The 1915 Bombay High Court judgment.
1915,
Yes.
1915,
Yes.
century old, more than 110 years old.
The
You don't have
principle-
any follow-up of this?
The principle of when 33 is to be invoked and when the threshold has been met is very, I'm going to say, comprehensively discussed in the Bombay High Court judgment. Subsequently, all matters are with respect to criminal cases, which is why I could not find.
Another one?
It is also very old, Calcutta High Court, 1922 judgment.
आपको तो पता करना पड़ेगा इसका प्रेजेंट स्टेटस क्या है.
Or be judgments in case I have to give, I'll give with my written notes. That liberty may be given. This Calcutta High Court is with respect to when disputed question of title will be entered into, when it will be said to be incidental in a partition suit.
The learned Bal Ganga
Yes. The one and the only.
वही है उन्हीं
Yes.
का.
I think so. Yes.
Interesting to read also. He has relied upon the judgment passed by the Bombay High Court, reported in 1915 bracket में रहेगा 17 BOMLR 527 bracket Bal Gangadhar Tilak versus Sri Srinivas Pandit decided on 26th of March 1915. बाल गंगाधर तिलक बोलने में भी अच्छा नहीं लगता है विदाउट श्री, उस तरह का नाम नहीं है.
इसका SCC का मिल लिया है प्रिंट आउट.
हम लोग इसका सारा हिस्ट्री पढ़ते हैं. एंड 1922 AIR सुप्रीम कैलकटा में
Cal 307 was Supreme Cal.
1922 AIR within bracket CAL bracket close 307 equivalent to 1922 Supreme within bracket CAL 19. It submits that it shall also look for any subsequent judgments on the point and place it on the next and furnish place it on the next date of hearing. The written notes of arguments and further judgments, if any, should be filed before this court latest by 16th. 17th को है आपका मैटर, सप्लीमेंट्री प्रोसेस. ये दोनों जजमेंट्स है ना, ये दोनों जजमेंट्स सभी ये दोनों जजमेंट को जरा वो बोलेंगे को बोलिएगा इसका हाँ वेरीफाई भी करनी और इसका बाद में कहाँ कहाँ फॉलो हुआ है, क्या हुआ है, दूसरे हाई कोर्ट में फॉलो हुआ है, इसको क्या पता है. बाहर से रखिए इसको. आपने ये इंडिया कानून से खोजा किताब नहीं पढ़ा होगा, नहीं पढ़ा ना, बुक पढ़ेंगे आपको उसमें अपडेट मिलेगा. कभी कभी बुक पढ़ने की ज़रूरत होती है. थोड़ा जी को बोलिएगा सरकार और एविडेंस इसमें सर्च करना.
Item 2, First Appeal 298 of 2023.
ये फाइल किया इसमें करेक्शन करना होगा. डिग्री और जजमेंट दोनों करेक्शन के लिए गया था लोअर कोर्ट. जजमेंट में केस नंबर जो था वो हमारा
आइए फाइल की
यस
आइए को रिकॉर्ड पर है.
आई नंबर है 4338 25.
433
ये 4 अप्रैल को हुई.
इसी केस में फाइल किया कोई और केस
नहीं
में?
इसी
आपको दिख रहा है लिस्ट में दिख रहा है?
हाँ लिस्ट पे भी दिख रहा है.
एक तो लिमिटेशन का आई है
नहीं वो सब तो हो गया सब
24
वो सब हो गया. अभी रिसेंटली हम 4th अप्रैल
एक काउंटर एफिडेविट दिख रहा है. नहीं डाली. क्या चीज़ के लिए अपना
ये फर्स्ट टाइम जो डिफेक्टिव लोगों के लिए गया था
डिफेक्ट में है अभी.
नहीं डिफेक्ट लग गया था. ये एडमिट भी हो गया था केस. जब एनसीआर वहाँ से आया तो हम लोग वेरीफाई किए उसको. जब तो एनसीआर में जो केस नंबर है ओरिजिनल केस नंबर वो केस नंबर इसमें रॉन्गली हमारा जो अवार्ड बना था वहाँ वो सही था. लेकिन अभी जो करेक्ट किए वो जजमेंट के बेसिस पे ये करती है. अभी जो करेक्शन होगा अवार्ड में देखा जाएगा. जो डिग्री है पेज नंबर 17
हाँ
पेज नंबर 17 में एली रिकॉर्ड नंबर 16 लिखा हुआ है.
ये 16 को हटा के 5 कर दिया है.
हाँ और वो जो जजमेंट में था वो 5 था. हमारा था कंटेंशन के नहीं 5 नहीं 16 ही हो. ये लोग उल्टा कर दिया. रिकॉर्ड में सारा दिख रहा है. वो आईए में लगाए हुए एग्जिबिट में भी आया है.
अच्छा,
सारा रिकॉर्ड जो
मतलब
वो
जजमेंट में गलती है, डिग्री में गलती
यस
है.
यस आईए का कॉपी
जजमेंट में इसका केस नंबर कहाँ लिखा है? हाँ, केस नंबर कहाँ लिखा है जजमेंट में? फर्स्ट पेज में LSC केस नंबर 5 ऑफ 2019 जजमेंट में पेज नंबर ये जो फर्स्ट पैराग्राफ में वही है, इसी में गलती है
हाँ इसी में
और आपकी डिग्री में सही है,
डिग्री में सही है
16 होना चाहिए।
16 होना चाहिए एग्जिबिट भी हम लगा दिया है
ठीक। आइए नंबर बताइए। आइए नंबर 4338 of 2025. The Learned Counsel for the appellant had submitted that though the office of this court has not pointed out further defects, but the interlocutory application has been filed to point out that the decree as corrected by the learned court, whereby land acquisition record number 16 of 2019 has been corrected to be land acquisition record number 5 of 2019-20. Is not as per the records. He submits that the error has actually crept in the judgment itself, wherein in paragraph 1, the land acquisition case number 5 of 2019-2020 has been mentioned, although it ought to have been land acquisition case number 16 of 2019-20. He submits that decree was rightly prepared, there was error in the judgment. Let the judgment and decree be sent back to the court concerned for necessary correction, along with a copy of the interlocutory application filed by the appellant. Pose this case on 17th of June in the supplementary cause list awaiting the report. एक काम और करना है आपको, ये so many sale deeds have been exhibited.
yes
So you have to give the area of the sale deed and the boundary so that we can compare it. Boundary की जरूरत नहीं क्यों हो सकती, लोकेशन exactly और लैंड एक्विजिशन का एग्जैक्ट डेट नहीं। तो ये क्योंकि उनका भी रिकॉर्ड है regarding the date, and they have also said that you have exhibited the sale deed which you have exhibited has also been considered in their rate charges. But we need to see when it comes to land acquisition, there should be comparable area also. That is also an important aspect.
इस केस में हालांकि वो इशू नहीं है, इसमें क्या है कि ये लोग कंसीडर किए हैं सर्किल रेट, जबकि इनको कंसीडर करना चाहिए था मार्केट रेट, इतना ही इशू है कुछ
नहीं, सर्किल रेट तो नहीं कंसिडर।
हाँ किए
इन्होंने ये बोला है कि जो सर्किल रेट नहीं कंसिडर किया है, इन्होंने जो रेट चार्ट होता है जो फर्निश होता है उसमें बहुत सारे सेल डीड्स का जिक्र होता है, उसके हिसाब से
या वही जो हमने भी जो एग्जिबिट किया है वही सेम, हमारा अलग से कुछ नहीं हम सेटिंग कर रहे हैं, जो ये लोग कंसिडर किए हैं उसी का सिर्फ इशू है कि ये लोग कंसिडर कर रहे हैं सर्किल रेट, देखा जाएगा
कहाँ इंप्यून ऑर्डर में कहाँ लिखा है कि सर्किल रेट के हिसाब से करना है? It is not mentioned in the impugn order.
हम वो रिकॉर्ड से दिखा देंगे, रिकॉर्ड में
Impugn order से नहीं पता चलता। 9257 per decimal.
हम इसको रिकॉर्ड से
As per your instructions, it is as per
Yes,
circle.
yes, yes.
The learned counsel for the appellant has submitted that the compensation which has been awarded in the present case is rupees 9250 per decimal, which was the circle rate at the relevant point of time. Although it is not apparent from the impugned judgment.
मतलब जो सेल्डीड है उसका ये लोग सर्कल रेट को कंसीडर किया, जो सेल्डीड सारा एग्जीक्यूट किए हैं
तो आप डेमोन्स्ट्रेट करेंगे ना,
हाँ
क्योंकि impugned judgment से नहीं पता चलता. The learned counsel has submitted that as per law, the compensation has to be paid at prevailing market rate, and the circle rate has no bearing in that. However, he submits that once the discrepancy in connection with judgment and decree is rectified, then he shall argue the case on this. ये मेरे मेमोरी के लिए. आपका आएगा 17 को सप्लीमेंट्री प्रोसेस. आप इसके लिए स्पेशल मैसेंजर कॉस्ट जमा करेंगे तो तुरंत चला जाएगा. The upon deposit of special messenger cost to be deposited by day after tomorrow, or maybe during this week by Friday.
Orders with effect item 3 first appeal 178 of 2018.
The limitation is there of 47 days. And the counsel for the railway, Mr. Sunil Kumar, is on next month. They said he is not serious on it.
उनका सबमिशन भी आपको
नहीं वो बोले कि मैं कन्वे कर देने के लिए बिकॉज ही इज ऑन नेक्स्ट.
उनका अपीयरेंस नहीं रिकॉर्ड कर सकते. आपने कन्वे कर दिया है, वो मैंने सुनी है. 27 दिन का डिले हम वैसे भी कन्वे करते हैं. प्रॉक्सी भी चलता है इसको, वो भी पिटिशनर के अपीलांट की तरफ से रेस्पोंडेंट का प्रॉक्सी. आपको कुछ ऑब्जेक्शन? Isn't it taking too much of liberty?
It's not.
Is it not taking too much of liberty?
No, but it's a simple just
इतना सिंपल है नहीं. आइए नंबर 2467 of 2022 in FA number 178 of 2022. When the counsel for the appellant has submitted that there is delay of 27 days in filing the appeal. He has also submitted that the matter arises out of land acquisition proceedings, and the villagers are poor persons, and in absence of able-bodied male member in the family who normally reside far away from their place in search of livelihood, the appeal could not be filed on within time. The learned counsel for the state has no serious objection so far as prayer for convocation of delay is concerned. Consequently, having gone through the petition for convocation of delay and being satisfied with the cause shown, IA number 2467 of 2022 is hereby allowed. ये कर दूँ सेम ऑर्डर? क्या करना? सेम करना है? उनको बुला लेते हैं. उनको बुला लीजिए. सेम ऑर्डर इसने भी उनका अपीयरेंस मेरे को. वो ऑर्डर का केस नंबर लाए हैं. ये फॉर्मली एडमिट नहीं हुआ है ना?
नहीं एडमिट नहीं हुआ इसलिए
ऐसे नहीं.
लेट फर्स्ट इट हैज टू बी एडमिटेड.
Admit The learned counsel for the appellant has submitted that the records of this case has already been received in
164.
FA number. उसका जजमेंट अपलोड हो गया?
हाँ हो गया 176 of 2018
176 of
2018 FNM
2018. And the case is squarely covered by the CNT Act. Considering the aforesaid submissions, post this case for final disposal. आपको कोई problem है? With the consent of the learned counsel for the respondents for final disposal, they are ठीक है? Office is directed to place the record of FA number 1, record received in FA number 176 of 2018 in this record. उसमें से निकाल के रख देंगे। वो जो दूसरा वाला FA डिसाइड हुआ था वो 2-3 दिन पहले उसका क्या नंबर है? FA number
164 of
164
2018
ठीक ये फाइल करेक्शन है
For admission item 5, first appeal 99 of 2023.
FA number 99 of 2023. Admit. Issue notice to the respondents are there. Yes.
yes
The respondents have already appeared. Mr. Number 10.
Kumar Singh ACTGP
Look at me. Waives service of notice on behalf of the respondents. Call for the records from the concerned board. What is the matter?
Your Lordship, this is for declaration of right title interest and permanent injunction, and also for cancellation of Jama Bandi order that has been passed by the DC, Your Lordship. In revisional settle survey, Your Lordship, it has been recorded as Anabad Bihar Sarkar, and on that basis, my mutation had been cancelled, Your Lordship. And that's when the cause of action arose and I had tried this suit.
You are the cooperative society.
No, Your Lordship.
The appellant is the cooperative.
Yes, Your Lordship, it's been.
Suit is barred. Suit is barred. 3 years been jailed. Close this case on appropriate under appropriate heading on 16th of July. Let this order be communicated. Record confirm करना है.
Item 6, contempt suit 266 of 2023.
So let's can we see the last order? Now the chairman has been appointed in JPSC.
आप बताइए.
In this case, we also filed an extension petition. There is some requirement here also, legal requirement, and that's it. IN number 5392 of 2025.
This was filed on 24/4/2020.
But,
On that day, you played for how many weeks?
my lord, I have prayed for your lordship.
3 weeks.
3 weeks.
तो 24 में से 2 हफ्ता था. अब 2 हफ्ता आपका पीरियड खत्म होगा ड्यूरिंग में.
During
ओपनिंग फ्राइडे को.
I think
अब ये मत बताइएगा कि आप छुट्टी.
हमारा एक प्रॉब्लम
नहीं कोई प्रॉब्लम नहीं है, आपने आगे फाइल किया है स्पेसिफिकली टाइम प्रे करते हुए कि इतना टाइम
जी
चाहिए आपको
जी
करने का।
एक हम क्यों रिक्वेस्ट करेंगे सब्जेक्ट टू लॉस ऑफ प्लेजर and all these formalities have been there is some legal requirement calling the expert etc. We are not getting your lordship. May I your lordship subject your lordship pleasure. But instead of the first Friday, I may not be here your lordship because I have to go to Hyderabad to drop my son your lordship on 9 or 10.
ओपनिंग मंडे को रख दो।
मंडे को नहीं 9 तारीख को ही आ गया है। अभी हो सकता है कि अगर बदल जाएगा 9-10 को आए तो I may come on 15th. If 15th after 15th then you get your lordship. That is my personal your lordship different.
ये contempt case civil 266 of 2023. Then the learned counsel for the parties are present. Counsel for the opposite party representing APSC has referred to IA number 5392 of 2025, filed by the affidavit dated 24/4/2025, seeking 3 weeks time to comply the order passed by this court in the case number 667 of 2019. Read with order dated 14/2/2024. 3 weeks would expire during the summer vacation. However, the learned counsel has submitted that in the first week after reopening, he has some personal difficulty and he has prayed that the matter be posted on any day after 15th of June. And by that time, the compliance report will also be filed before this court. Who will appear if the compliance report is filed?
But that is your lordship secretary. But that occasion will not come your lordship. I have a long discussion with the secretary your lordship. We will be complying the order your lordship within the shortest period time your lordship. If it is not complied then your lordship on 14th, on 16th or 17th your lordship, then your lordship can. But it will be
The
complied
learned
before
counsel
that.
has assured this court that the compliance report will be filed latest by 16th of June. And in case it is not filed, the court may proceed for initiating appropriate proceedings.
Court may pass any order.
What any order?
Any order.
No. Any order. This is what you are saying. Court may initiate appropriate proceedings, and the same would be out of control of the counsel appearing representing DTs. Correct? Yes. It has to be.
That may not be.
No, no.
That.
It will be out of your control.
नहीं
भाई आपने आईए फाइल किया 3 हफ्ता वेकेशन में रख देते What is this? कौन समझ
But
गया
I
ये
assure
फाइल?
your lordship, my lord every.
वही आपके एश्योरेंस की बात लिख रहे हैं. Post this case on 18th of June in the supplementary cause list. The compliance report should be filed latest by 16th of June. In case the compliance report is not filed, the इसका एफिडेविट चाहिए.
मतलब that is your lordship secretary of information. Akshay
Opposite party number.
3 your lordship. 3.
Opposite party number 3 is directed to join the proceedings online to explain as to why the order passed by this court and the undertaking furnished before this court has not been done.
मतलब before that complication. Why is it? Before that it will. Even I will try to comply with your lordship during the vacation itself. I assure you.
Item 7, Contempt Civil 498 of 2024.
In this case your lordship.
Wait. Although you have not filed so far, your lordship, kindly talk to page 130. 130 of the contempt. On the
अब कंटेंट इतना मोटा फाइल कर सकते हैं।
अच्छा एक जो मेन ऑर्डर है 84 पेजेस का बाय द डिवीजन पे पेज 130 that was the basis for disposing the writ application paragraph 59 130 may I place in view thereof, respondent both state and the JPSC are directed to notify the advertisement for acceptance of application of such candidates who have been appointed on compulsory ground, if they are otherwise eligible, by taking sincere endeavor for conclusion of process of selection within the period of 3 months from the date of receipt of the copy. Thereafter, you will come to page 133.
पेज 60 नहीं पढ़ी, पैरा 60 भी पढ़ी।
हाँ 60 भी पढ़ा है।
पढ़ी।
रिजल्ट के डेट उन लोग उससे हमारा मतलब नहीं है, हमारा है कि कंपल्सरेट ग्राउंड पर हम लोग अपॉइंट हुए
हमारा
हैं।
मतलब है कि आप पैरा 60
अरे पढ़ो। The JPC in that pretext hereby directed not to publish the result of candidates who have already participated in the written examination, so as to publish the result cumulative after assessing the candidature of one or other candidate who have been appointed on compulsory ground. Thereafter, you will come to page 133, para 3. Para 3. Let us continue the petitioner submit the examination so conducted long back but result had not been published and also submitted by virtue of the order passed in WPS 7/1990 Chandan Kumar. Certain direction was issued as contained in para 58 to 60, whatever I placed. Thereafter, now it was passed in February 24. Now they have advertised the post of 28 posts with regard to compensate report. My humble submission would be that the main order was passed in December 22 and the writ application in this regard has been passed in February 24. More than a year already lapsed due to non-availability of the chairman whereas is that. Only humble prayer before this court would be to let the matter come up after 3 months, 4 months. In meantime, he should complete the process of selection whatsoever.
They have already advertised it.
Advertise.
So they are acting in terms of the judgment passed by the Honorable Division.
There is the time was fixed. Therefore,
That's
only
right.
humble.
Just अरे भाई आप मेरा बात तो सुनिए. फिर डिवीजन बेंच में जो डायरेक्शन हुआ था बिलेटेडली ही सही, वो लोग उसको कंप्लाई कर रहे हैं.
First part, they advertised, but selection process को कंप्लीट करना था विदिन 3 months.
वो उस सिलेक्शन प्रोसेस को कंप्लीट करने के बाद ही बाकी लोगों का रिजल्ट पब्लिश होगा.
हाँ, तो
जब वो सिलेक्शन प्रोसेस कंप्लीट होगा तो आपका रिजल्ट पब्लिश होगा.
सिलेक्शन प्रोसेस के लिए केवल मेरा रिक्वेस्ट है कि इसको 3 महीना 3 महीना 4 महीना.
You see, they have now taken action in terms of the judgment passed by the Honorable Division Bench, though belated.
That I have not advanced on that.
So
they should complete further. They should complete the process within time. That is one.
They'll do it.
Kindly see,
What
is the order passed by your lordship and what is he arguing? That is altogether different.
Let us see what
Kindly
is
I
the
have a look to annex page 134 of the contempt application. Para 5, your lordship. 134. May I read your lordship? In the light of the aforesaid submission, this court is of the considered view that no useful purpose will be served by keeping the writ pending. Apparently, the matter is under active consideration of the respondent number 1 and 2 as per the letter dated. Appropriate order of the direction is required to pass issued by the respondent number 1. This court is also of the view that matter regarding the individual claim to have participated cannot remain pending for a limited period of time, since of the indecisiveness on the part of the respondent has a serious bearing on the career of the even the respondent were directed to take a decision in the matter are not later than 3 months from the date of
What is the date of advertisement?
That is
advertisement 2-3 days back it has been.
बताइए नंबर.
डेट इसमें तो नहीं है, केवल एक नोटिस था, नोटिस के आधार पर.
It has been advertised just 2-3 days back.
I don't know to find your lordship. I don't receive the notice your lordship.
नोटिस
कब हुआ है? 24.
2/5/2000. 25 को हम लोग निकाल दिए हैं
2025 को आपने ये उनका कॉम्पैशनेट वाला निकाला।
हाँ नहीं, हम लोग कॉम्पैशनेट का उसमें हम लोग पहले आफ्टर पासिंग द ऑर्डर बाय द ऑनरेबल डिवीजन में the rules were amended, your lordship, and after the amendment of the rules, your lordship, the proceedings were carried out and decisions have been taken jointly by the JPSC and the state government for publication of the advertisement, your lordship, in terms of the.
So what will happen to those who have already participated?
My lord,
उसको scrap कर दिया आपने?
नहीं, my lord, in terms of the order of this honorable division bench, my lord, we will have to pass the order, your lordship, collectively, your lordship. Before completion of this proceeding, your lordship, we can't.
No, as per the direction of the honorable division bench, right? Both the state and JPSC are directed to notify the advertisement for acceptance of application of such candidates who have been appointed on compassionate
Madam.
if they are otherwise eligible, by taking sincere endeavour for conclusion of the process of selection within a period of 3 months from the date of receipt. So we have already taken it.
We have decision.
What will happen to para 16? The JPSC in that pretext is hereby directed not to publish the result of the candidates who have already participated in the written exam, so as to publish the result cumulative after assessing the candidate of one or the other candidate. So any particular selection of the candidates who have already participated will be subject to this particular decision.
Absolutely correct, your lordship. Now, your lordship, we have taken the decision. My lord, rules have been amended. We have also issued notice that the advertisement will be published and we will have to submit the online application form, your lordship. From your lordship.
Even the petitioner will have to submit.
My lord, the petitioner will have to submit, your lordship. And thereafter, after submission of the application form, your lordship, we will have to. We will have to take decision.
If you have any fresh cause of action, you will.
हम केवल रिक्वेस्ट यही है कि ये जो in terms of this notice, they should complete the process within 4 months, 5 months, 5
Contempt है ना,
months.
आपके रिक्वेस्ट से नहीं चलेगा, ये मेरे satisfaction से चलेगा.
My lord, your lordship had been
Taken
pleased to pass
notice
the
हो
order,
चुका
your
है,
lordship,
अब process
to
केवल
take
complete
decision,
करना है.
and we have already taken decision.
देखिए contempt civil 498 of 2024.
Otherwise, we have
The
to
learned
come to
counsel
court.
for the parties are present.
ये तो अगर डिवीजन बेंच का ऑर्डर का कंप्लायंस विद इन टाइम कर दिए होते तो रीड फाइल लेने का, इसलिए आप
This petition
humble
has been
submission.
filed alleging non-compliance of order dated 13/2/2024 passed in writ application WPS number 3120 of 2023. The learned counsel for the petitioner has referred to the judgment passed by Honorable Division Bench
page 130. What 290 start
in
from
WPS number 790 of 2019 and other analogous cases, wherein following directions were issued, paragraph 59 and 60 at page number running page 130. The learned counsel has thereafter referred to the order passed in WPS number 3120 of 2023, wherein it was observed that the wherein the submission of the petitioner was recorded in paragraph 3, that the examination were conducted pursuant to the concerned advertisement number 11 of 2018 long back, but the result was not furnished, and even the directions contained in WPS number 790 of 2019 in paragraph 58 to 60 was yet to be complied. And in that circumstances, a direction was issued by this court. This court was of the view that no useful purpose will be served by keeping the petition pending, as it was under active consideration of the state of Jharkhand as well as Jharkhand Public Service Commission, who were required to take appropriate action. It was also indicated that the matter regarding recruitment in which the petitioner claims to have participated cannot remain pending for an indefinite period of time. And a direction was issued to take a final decision in the matter within a period of 3 months from the date of communication. The Learned Counsel submits that this happened way back on 13/2/2024, and on 2/5/2025, JPSC has come up with advertisement.
Notice, Your Lordship.
Notice.
Notice regarding, Your Lordship, publication of the advertisement.
Okay.
on
Notice
20th
regarding publication of advertisement. The Learned Counsel has submitted that this matter be adjourned for 3 to 4 months, and in the meantime, the final outcome may be placed on record. The Learned Counsel, appearing on behalf of the respondent JPSC, has submitted that the state government and JPSC have taken a decision and the rules have been amended, and now the process is on, and the order passed by this court in WPS number 790 of 2019 by Honorable Division Bench is in the process of compliance, and the same could not be complied on view of the fact that the post of JPSC remained vacant for quite some time. Chairman JPSC remained vacant for quite some time. He has submitted that once the process has already begun, there is no reason that the fresh advertisement will not be taken to a logical end. He submits that no useful purpose will be served by keeping the contempt proceeding pending, and the respondents are in the process of complying the order. He has further submitted that if the petitioner has any grievance thereafter, that would be a fresh cause of action. How much time it is likely to take?
Madam, it will be, Your Lordship, depending on the numbers of the post. Your Lordship,
28 post.
numbers of the application received. Your Lordship. Madam, if it is because we have
This notification is what? This is not an advertisement. Notice for advertisement.
Notice, my lord, before publication of the advertisement, the notice is to be published, Your Lordship,
Notice is to be
for information to the candidates, so that
Advertisement
may,
कब आने वाला?
my lord, that is, Your Lordship,
बीस
indicated
मई से उसी बहस
20th March
20 मई से आपको
2025.
The Learned Counsel has also submitted that as per the notice, the advertisement is scheduled to be published on 25/2025. After hearing the Learned Counsel appearing on behalf of the parties, this court finds that certain steps have been taken to issue fresh advertisement in terms of the judgment passed by this court by Honorable Division Bench in WPS number 790 of 2019. And therefore, the follow-up order by this court in WPS number 3120 of 2023 dated 13/2/2024, in connection with which the present contempt application has been filed, is certainly cumulatively be taken care of by the decisions to be taken by the opposite parties. The notice for advertisement has already been issued, and the scheduled date for advertisement is
डेट से हम लोग को फॉर्म भरना है पैराग्राफ 2 जो है ऊपर
ये तो उसी एडवर्टाइजमेंट होगा तो फॉर्म में ना भरना होगा सर।
परीक्षा से संबंधित विज्ञापन एवं ऑनलाइन आवेदन का भेद प्रपत्र एवं विस्तृत विवरणी आयोग के वेबसाइट
In
20
view of the
5
aforesaid
25
facts
से
and
उपलब्ध।
circumstances, this court is of the view that no useful purpose will be served by keeping the contempt proceedings
प्रोसेस को
and accordingly the contempt proceedings is hereby dropped if the petitioner has any grievance pursuant to any selection process arising out of the advertisement to be published by JPSC. It will be open to the
दैट इज
petitioner to take steps as well.
मेरा यही था कि एग्जामिनेशन क्लियर कर लेते 3-4 महीने के अंदर एज पर ही चॉइस।
और डिप्टी हो गया।
जेपीएससी जैसे इंस्टीट्यूशन पर हम लोग अननेसेसरी प्रेशर नहीं क्रिएट कर सकते. That
We are
is-
already overburdened, Your Lordship. Because Your
तो
Lordship,
आप
now we
अपना
are
काम
going.
छोड़ के उसको डेलीगेट कर दीजिए.
नहीं हम लोग कर रहे हैं, सारा कर रहे हैं. देखिए अभी हम लोग ये लेक्चरर का निकाल रहे
ऐसा
हैं.
तो आप बोल ही नहीं सकते.
नहीं बोल नहीं सकते. वी आर डूइंग Your Lordship. As per
अरे
our
तो
best
22 से
ability और
25 हो गया है.
सारा हम लोग कर रहे हैं.
और
आपको ये नहीं भूलना चाहिए कि आप झारखंड में हैं.
ये तो
जहाँ पे कोई भी एडवर्टाइजमेंट बिना लिटिगेशन के खत्म
होता ही
नहीं
नहीं है. 2016 18 में staff selection committee is still going on. Now it is 2025.
Item 8, first appeal 45 of 2025.
खाली मेरा वही था कि
देखिए फर्स्ट अपील नंबर 45 ऑफ 2025 काउंसिल फॉर द अपील डिस्कस suit has been dismissed.
Should have been.
Admit. Let notice be issued to the respondents for which requisite under ordinary process. सब झारखंड के हैं?
हाँ सर.
Be filed by Friday. Let the records be called for from the concerned court. Post this case on 22nd of July under application.
For getting under order 41/11, item 9, second appeal 109 of 2018.
Page 26 of the trial court judgment is established from page 26.
What is the substantial question of law?
The substantial question of law was as framed earlier. It is
This is an admitted appeal.
no,
Earlier
only one
means,
limitation notices.
earlier means we have already framed substantial.
No, limitation means has been condoned
That's
after issue.
what is the substantial?
So means the first substantial question of law is because I have also filed one additional substantial question.
Where is exhibit 1?
Exhibit 1 is
Where is exhibit 1?
exhibit 1 is LCR is not involved.
You don't need to. When you are arguing, where is it? You have exhibit 1. Then how do we know whether the exhibit 1 has any description of property or not?
That is not that was in Bengali. I have asked for the transcription.
देखिए ऐसे नंबर 109 और 2018 तो इसका तो ट्रांसलेटेड कॉपी लोअर कोर्ट में भी फाइल हुआ होगा.
वो भी exhibited है.
एग्जिबिटेड है.
It's part of
तो
And
रिकॉर्ड
that is
कॉल
the main-
करें क्या करें?
Yes, miss. That is the main basis.
Before, that can be done only
Only-
after admitting.
No,
after
not
framing a
can't.
after framing
Not
substantial.
necessarily because she is referring to exhibit 1 by saying that it does not have the bounds.
That admission can be done after that.
Admission because we need to see the
Yes,
record.
yes, yes,
Yes.
that needs to.
उसके बिना कैसे हो?
Yes.
ऐसा सब्सटेंशियल क्वेश्चन ऑफ लॉ बनाने के पहले तो हम लोगों को थोड़ा डॉक्यूमेंट तो देखना
Yes.
पड़ेगा.
But those issues can be referred to the findings of the learned court below. I can show those findings.
अगर फाइंडिंग्स
There
में
is-
परवर्सिटी है तो
इससे
substantial
इससे भी
question
पता
of
चल
law.
सकता है. इससे पता चल सकता है. Even though
रिकॉर्ड
no
मंगा
ladies
लेते
in
हैं. रिकॉर्ड मंगा लेते हैं
Yes.
और आपको सुन के ही करेंगे.
Yes.
Yes. ठीक है. अगर मान लीजिए कोई एग्जिबिट में इतना सीरियस एरर है किसी एग्जिबिट से रिलेटेड तो इट गोज टू द रूट ऑफ द मैटर.
Yes, no. That,
करेक्ट.
yes, that.
Essay number 109 of 2018. The learned counsel for the parties at present. The learned counsel for the appellant has referred to additional substantial question of law and which refers to exhibit 1 and has submitted that the description of the property itself is missing in exhibit 1. She submits that the records we call for from the concerned court as perusal of Exhibit 1 would be necessary before framing substantial question. You are the sole respondent.
There are 6 respondents.
You are
I'm
representing
for
all
all.
of them. The learned counsel for the respondent representing all the respondents is present who was issued notice only at the stage of limitation. Let the records be called for from the concerned court. The record should necessarily include Exhibit 1, its typed copy, if any, and translated copy. कभी-कभी कुछ missing हो जाता है. आप भी अपना देख लीजिए.
I'm looking.
The counsel for the appellant has also undertaken to produce a copy of Exhibit 1 with its typed copy and translated. बगला पढ़ना आता है?
I'm depending on the translated documents because the court has also depended on that. That will suffice.
डेट कौन सा दिन बताइए?
After limitation,
2nd of July?
well,
Post on 2nd of July. नहीं एडमिट नहीं करेंगे. सब्सटैंशियल क्वेश्चन ऑफ लॉ बना नहीं है.
Item 10, second April 34 of 2023 along with item 11.
This is a defendant's second appeal.
Why 2 people?
Because this was a suit for cancellation of the sale deed. The trial court cancelled my sale deed but also ordered that consideration amount should be returned to me. The plaintiff also preferred an appeal. We preferred an appeal against the cancellation of sale deed. Plaintiff preferred an appeal against the direction for refund of consideration amount. My appeal has been rejected and his appeal has been rejected. So the second case is arising out.
So in both the appeals, 2 distinct substantial question of law.
That is only restricted to refund of the consideration amount. And in the present case, may I just briefly watch this? Plaintiff, he instituted the suit for cancellation of the sale deed, which was entered by him in my favor. His case was that he was intoxicated, he has not received any consideration amount, and he used to sign his literate, he used to put his signature, but in the sale deed, his thumb impression is there. We appeared, we filed our written statement, and we proved that this was not the only sale deed which was entered on that date. By this sale deed, he transferred the land in my favor, and through another sale deed, this was sale deed number 3640, another sale deed number 3641, he purchased the land from one Tilak Man. Purchased. There also he put his thumb impression, so he cannot be intoxicated while executing my sale deed. And
ये कब का है sale deed?
Sale deed is of the year 2006.
2006 में purchaser का signature नहीं होता.
In any case, 2 sale deed were entered. Our condition.
2006 में purchaser का signature नहीं होता. Seller का खाली.
Seller.
एक समय ऐसा था ना? Are you aware?
No, in this it has come that he has put his thumb impression in both the sale deeds.
Okay.
Then, in course of argument, he changed his entire argument and he says that the sale was barred by section 46 of the CNT. This was neither pleaded anywhere nor any evidence was adduced, and the learned trial court passed order on the pretext that the sale deed was hit by section 46 of the CNT Act.
It belongs to which class?
That is nowhere pleaded.
Neither pleaded nor proved nothing.
Nothing. No issue has also.
Then what is the finding of the learned trial?
Learned trial court has that since party belonged to Mahato, so a presumption has been drawn that they will be belonging to.
कौन सा substantial question?
Yes, Lordship. First and the first one, whether both the learned courts below in traveling beyond the pleadings and giving a first finding regarding applicability of section 46 of Sotanatu Tenancy Act in the present case as plaintiff.
और बताइए. That should be sufficient.
2 also, because assumption and presumption has been drawn. that because parties are Mahato, so they belong
एक ही
to.
बात है ना, one से सारा cover हो जाए.
After all, it is beyond pleading.
That's right. One will cover everything. One will cover everything.
Yes, Your Lordship, one minute.
Roman 4. That will be for the other case.
In the other case, Your Lordship, I have taken the account of unjust enrichment also. Because once it has been held that he has taken the consideration amount and subsequently he cannot take my land will also be taken away and now consideration amount will also not be refunded to me. So 2 points. Apart
That
from
would be sufficient then. One is sufficient over here. And then here in the other appeal, what would be the substantial question?
third one. The second one, 3 and 5, Your Lordship.
Does there any relief break for recovery of this amount?
No, we did not. Because plaintiff had instituted the suit.
Both of you are Mehto.
Yes, Lordship, we are not. But presumption cannot be drawn. Your Lordship are aware that in cases relating to unless and until it is pleaded,
No, it has to be pleaded.
it has to be pleaded.
Merely because a person is writing Mehto, that doesn't take you anywhere.
Yes, Your Lordship.
In the 18 is the caste mentioned.
No, Your Lordship, no way.
You, for the second record, you wanted which question of law? Roman 4? This second appeal number 49 of 2023. और रोमन 1 से हो जाएगा नहीं, तो इससे तो रिफंड से मतलब है ना. देखिए पढ़िए सर.
Whether the learned first appellate court failed to consider that learned trial court did not give any finding on issue number 4 as to whether statute number 3640 dated 26/7/2006 was duly executed by plaintiff or not, and rather went to decide applicability of section 46 CNT Act without any pleading and held that said deed is barred by law, which itself shows that learned court below have found the execution of said deed as valid, and as such trial court learned trial court also ordered for return of consideration amount of rupees 2,50,000 to them.
CLD valid होगा तो return of consideration amount कैसे?
Because execution is not denied. It is only held that this sale deed is hit by section 46. So when it has been held to be null and void, then the consideration amount which has been taken, that should be returned.
That should be returned.
Because that would be unjust enrichment. My land will also be taken away, amount will also be taken away. And number 6.
Roman 2 को क्या बोलना है? Roman 2
Yes,
Roman 2 would suffice, I think. Then
yes, sir.
proceed.
2 and 6, Your Lordship, may kindly proceed. Whether the learned lower appellate court erred in discarding the judgment of learned trial court in terms of returning of the consideration amount of rupees 2,50,000 to the appellant as same amounts to unjust enrichment to the plaintiff.
The learned trial court asks for refund,
Yes, directed.
directed for refund, and the learned first appellate court
Set aside that finding.
set aside the finding on section 46.
On section 46, and it presumed that presumption is there that if the Lordship may kindly come to page 43 for me.
Yes.
May I just read last paragraph? But while deciding issue number 7, learned trial could also direct the plaintiff to return the consideration amount to defendant. No relief has been sought for regarding the consideration amount of the said deed number such and such. No parties claims for said consideration amount, and no such issue has been framed. The admitted fact in this regard, in regard to the said deed, is that same was prepared for sale of land belongs to the plaintiff. It is the case of the plaintiff that defendant cheated plaintiff, and during intoxicated state of plaintiff, defendant obtained his thumb impression on said deed. He neither sold his land nor taken consideration amount. Whereas defendant pleaded that plaintiff in sound mind executed said deed to him and received the consideration amount. Peruse the oral and documentary evidence of both sides. Plaintiff PW4 stated in para 19 that he earlier given money to Trilok Mahto for a land which he purchased, and it is wrong to say that for the said payment he sold his land and he not sold land. During his cross-examination in denial stated that it is not true that on getting consideration amount from defendant he purchased other land. Both the plaintiff and defendant are from backward classes of same district, and as per section 46 of CNT Act, without obtaining permission from the deputy commissioner of person of said classes, can't transfer the land. Plaintiff himself denies about execution of the said deed in para 35 of the cross-examination and make charges upon the
The
defendant.
appellate court was of the view that there was no prayer for refund of
Refund of the amount, because it was the plaintiff's suit.
He could have filed a counterclaim or alternative relief or
No, we were defending our sale deed that it was validly executed. It only came when our sale deed was declared as null and void and direction was passed. And both the courts have presumed that since they are Madhu, then they belong
I
to.
think Roman 6 should be sufficient for this.
Yes,
We'll see whether unjust enrichment का plea आपका in absence of any relief can be taken care.
that I'll have to.
That you'll have to work on. I think Roman
Because
6
if
हो जाएगा.
my first appeal is allowed, first second appeal is allowed, then this will become
Infractions. But in case that is not
Yes,
allowed,
that is
then
not.
also whether the refund could have been sustained
sustained.
is something which is required to be seen. Admittedly, there was no relief by the
Because
defendant
it was
so far as
and
refund
we
of
have not
fees.
filed any set of counterclaim on
The learned counsel for the appellant is present. He has submitted that the defendant is the appellant in both the cases. The suit was filed for cancellation of CNT by alleging that the sale deed was executed under influence of intoxication. The consideration amount as per sale deed was 2,50,000. The learned counsel has submitted that the learned trial court cancelled the sale deed and उसमें 46 था trial court में
46 पे ही हुआ है दोनों.
the learned trial court cancelled the sale deed by referring to section 46 of Recruitment Tenancy Act and assumed that and such cancellation was beyond the pleadings of the respective parties. Inasmuch as it was never the case of either parties that the sale deed was felt to be cancelled on the account of it being violative of section 46 of CNT Act and that both the parties were belonging to backward class community. The learned counsel submits that both the plaintiff and the defendant were aggrieved by the judgment passed by the learned trial court. The plaintiff was aggrieved in connection with cancellation of the sale deed.
Defendant.
The defendant was aggrieved in connection with cancellation of the sale deed and the plaintiff was aggrieved by the direction to refund the amount of rupees 2,50,000. And therefore, two different appeals were filed. The learned first appellate court sustained the cancellation of sale deed again by referring to section 46 of Recruitment Tenancy Act and without considering that it was not based on any foundational pleading. And so far as the refund of rupees 2,50,000 is concerned, the learned first appellate court interfered with that direction by observing that no such relief was paid for before the court. The learned counsel has submitted that consequently the plaintiff is deprived of the land as well as the consideration amount which was given to the defendant. Given by the defendant.
By the law.
He submits that the second appeal number 34 of 2023 be admitted on first substantial question. हो जाएगा? Sir?
First
What
and
is
fourth.
it?
First and fourth.
First and fourth substantial question. एक sentence only. The learned counsel has submitted that on the same day there was another sale deed executed in favor of the plaintiff, which was sale deed number 3641 dated 26/7/2006. 1 and 4 कर देंगे. And so far as the essay number 49 of 2023 is concerned, the learned counsel has submitted that it be admitted on substantial question of law number 6. Right? These two second appeals are admitted on the following substantial question of law. Essay number 34 of 23 जाएगा 1 and Roman 4. ठीक है? और ऐसे 49 of 2023 जाएगा 116 वोट कर देंगे इसमें. Issue notice. How many respondents?
Sole respondent.
To the sole respondent, for which requisites under ordinary process be filed in both the cases separately. Let the records be called for from the concerned court. Post this case on 30th July under application.
For hearing item 12, second appeal 5 of 2016.
This is substantial question of law has been framed. My lordship, just one thing, my lordship. This applicant, he has died, and while order dated 22/6/23, the registry was asked to just make the parties and change the cause title, my lordship. But that has not been done.
22/6/23. You were substituted.
Yes, ma'am. We have filed the Wakala, ma'am.
Registry has done it.
Last I did it.
First. बताइए उनको कुछ error है क्या इसमें?
List his name was uploaded.
Sorry?
The list, this applicant, this deceased applicant's name was on this query, my lordship. That is why.
I can't get you. It is there.
Yes, my lordship, in the list also the name changes.
So you will go by the list, you will not go by the records. Yeah? What is your case?
My lordship, one question of law has been framed.
Yes, what is that question of law?
Whether non-consideration of Exhibit 6 series by the trial court as well as the appellate court comes to the root of the case as Exhibit 6 series has not been considered by the court below, and interpretation of a document is a substantial question of law.
So that itself is a part of question of law.
Just the non-consideration of that.
बताइए exhibit 6 series में क्या है? What is the consideration? They are not considered it at all. No means they are not referred to it. Yes. You are reading it for the first time in the court. Where is the consideration of? Where is the mentioning of Exhibit 6 series? And what was Exhibit 6 series?
Certain settlement of the
इनका
revenue.
वो voice नहीं दिया है.
My relation, there was my relation, there was a settlement case, my relation. The revenue records were changed. In the revenue cases, the name of this appellant and his ancestors had already been changed, my relation, but that has not been considered.
So revenue records will not create
It's a
a
settlement case was there.
Yes. So
My relation, so all those were not considered by the trial court and the appellate court. In page 24 of the trial court order, it is.
you come to appellate court study. Exhibit 6 series of the orders was in settlement case against defendant number 1, where the revenue courts have refused to settle the suit land in his name after the plaintiff had filed objection. So what consideration does it require? That is why there was a cause of action to file the suit.
Even the revenue courts have held that this defendant's name cannot be mutated by leadership.
So how does it, is it binding on the court? Revenue court will hold many things.
But there was a settlement case as well, my leadership.
So where is the settlement deed? Where is the final settlement? And there is a ultimate acknowledgement by the state that the property has been settled in your favor. You were issued rent receipts.
Yes, my leadership.
What was the suit for?
I know for the
Title and confirmation of possession.
yes, my leadership.
Correct? So you were claiming title on what basis?
My leadership on the basis of a sale deed, my leadership.
So, who executed the sale? What is the sale deed number?
My leadership sale deed number 5159.
You read the trial court judgment. You read it. Let us see the cause of action. Read the trial court judgment.
The present suit has been brought on behalf of the plaintiffs for declaration of title and confirmation of possession of suit land described more fully and specifically in the schedule of the plaint.
as stated in the plaint in a nutshell is that the land described lawfully and specifically in the schedule to the plaint is recorded as Anabad Malik land in the cadastral survey record. According to cable number 2/1, was recorded in the name of Ramesh Chandra Chakrabarti. Cable number 2/2 in the name of Shama Chandra Chakrabarti. Cable number 2/3 in the name of Ashutosh Chakrabarti, Nakul Chakrabarti, and Sahadev Chakrabarti. Cable number 2/4 was in the joint cable holder 2/1, 2/2, 2/3, while cable number 2/5 was recorded in the name of Tribhuvan Chakrabarti. The entire cable 2/3 was purchased by Tribhuvan Chakrabarti. Cable holder number 2/5 by virtue of a sale deed number 217 dated 9/1983. Tribhuvan Chakrabarti
83 or 33? 83. Is the confusion about the date?
Chakrabarti further purchased 1/3 share in cable number 2/2 from Shama Chandra Chakrabarti, including the suit land, by registered deed number 5159 dated 29/8/1983. 1989. It is the case of the plaintiff that the said Tribhuvan Chakrabarti remained in possession of the land in cable number 2/2, 2/3, 2/4, and 2/5, and the name were saved under the Bihar Land Reforms Act, and M form was accordingly issued by the state of Bihar after the question of the proprietary rights. It is further the case of the plaintiff that Tribhuvan Chakrabarti died, leaving behind his 3 sons, Pashupati Chakrabarti, Raghupati Chakrabarti, and Ganpati Chakrabarti, and all of them submitted their return to the state upon which M form was issued to them. It is the case of the plaintiffs that the 3 sons of Tribhuvan Chakrabarti sold the plot number 423, area 1.6 acres, out of which 0.45 acres in Khata number 18, Mauza, Dhanbad, has been sold to Kailash Singh, the plaintiff herein, by deed number 11643, dated 10/12/1985. Morefully, they have already sold 0.5354 acres in plot 423 area and 1.60 to Ramayan Trivedi. It is the case of the plaintiffs that the defendants having land under his ownership, therefore was not a landless person, and despite that, the Dhanbad for settlement of land as described in Schedule A of the plaint. Thereupon, the Halka Karamchari in his report in settlement case number 5 of 8889, so instituted dated 22/10/90, recommended cancellation of the settlement in favor of the defendant number 1, upon which the order dated 21/2/91 in the matter was settled by LRDC Dhanbad. Then the learned LRDC Dhanbad thereafter by order 6/9/91 rejected the proposal of settlement in favor of defendant number 1. The defendant being aggrieved by the said order of impeachment filed miscellaneous review appeal case number 58/91 before the additional collector of Dhanbad. The appeal was dismissed by order 17/9/92. Accordingly, the defendant in a proceeding case of 144 CRPC with respect to the suit land, which was registered as MP case number 2146 of 1992. Before the SDM Dhanbad, the learned SDM Dhanbad, while order dated 15/12/92, made this sold against the plaintiff and in favor of the defendant. It is the case
This
of
15/12/92.
Yes, ma'am. Which is against all the settlement orders of the LRDC as well as the.
Which exhibit is this? 15/12/92.
6/B, MP case number 110 of 94.
In MP case number 104 of 94, the order was passed in 92. Which are these documents referred to? Settlement case number 5 Representative Committee of 88-89.
Yes, my dear.
This is Exhibit 6.
6A is the certified copy
Just a
of the
minute.
messages.
This is Exhibit 6. Okay. Then 6A is certified copy of miscellaneous revenue appeal, 58 of 92. Which is 58 of 91 perhaps. This is also mentioned 6 by A. Correct?
Yes, ma'am.
6 by B, CC of MP case number 110 of 94. 110. MP case, where is it mentioned? MP case number 110 of 94.
And usually the appellate court's order in the table it
Right.
is mentioned.
Right.
And usually there are two MP cases validated. One, there has been a confusion in this table because one of it was filed by us in 92, wherein this order under section 144 was vacated.
what was you were claiming by virtue of settlement?
The settlement, the vendors who sold it to us, they had been settled in the election.
Who were your vendors? They are also party in the proceedings?
Chakrabarti's 3 sons, no, my lordship, they are not party. And we have also further sold it to another person also, my lordship, some part of the. This main person who got settled is Tribhuvan Chakrabarti.
What is the date of settlement? What is the date of settlement? And which is the document of settlement?
My lordship, just the Khevat where it has been recorded.
I settled in your favor?
Yes, my lordship. Not in my favor, my lordship.
You this is an interest?
Yes, my lordship.
Which is that exhibit, Khevat? Which is that exhibit?
That has not been brought on record.
So these documents are not of much material.
Later, one portion of the cable was settled in this person's. The seal from which this Tribhuvan Chakrabarti got it, that has been exhibited by later. Seal number, which is exhibit 1, 2, and 2 by 1.
You read the case from the appellate court statute. The trial court judgment is handwritten and it is not legible. You don't even ask me to file a typed copy of that. Read the appellate court statute. Para 3.
The case of the plaintiff, as stated in the plaint, is that the sold property stood recorded as Anabad Malik land in the last cadastral survey record of rights. According to the plaintiff, cable number 2 by 1 stood recorded in the name of Ramesh Chandra Chakrabarti, cable number 2 by 2 recorded in the name of Shama Chandra Chakrabarti, and cable number 2 by 3 stood recorded in the name of Ashutosh Chakrabarti, cable number 2 by 4 in the name of cable number 2 by 4 is the joint cable holder of 2 by 2, 2 by 3, 2 by 1, 2 by 2, 2 by 3 stood in the name of Tribhuvan Chakrabarti. In the
What
last.
does that mean? Ismail Khevat. What does this mean? What does this mean?
I'm not very sure my leadership, but it was settled in the name of this Tribhuvan Chakrabarti.
No, this like after Khevat number 4, 2 by 2, 2 by 3, 2 by 4 is Ismail Khevat. Khevat number 2 by 4 is Ismail Khevat of Khevat holder number 2 by 1, 2 by 2, 2 by 3. Stood recorded in the name of Tribhuvan Chakrabarti in the last registry survey. So it is joint Khevat in the name of 3 persons. How does this person, the third person, comes into picture? Tribhuvan Chakrabarti.
It is said that he also bought certain shares. The purchase has been made by Tribhuvan Chakrabarti in plot number 440 area 0.14 acres.
Okay, read further. Continue.
Subsequently, Tribhuvan Chakrabarti Khevat holder number 2 by 5. He was originally the Khevat holder number 2 by 5. Purchased the entire estate from Khevat holder number 2 by 3, namely Nakul Chandra Chakrabarti, Shahdev Chakrabarti, and Vibhashna Divya, wife of late Ashutosh Chakrabarti, by a registered deed number 217 dated 9/2/1933. All these have been exhibited by each for valuable consideration. He further purchased 2 by 3 share in the Khevat number 2 by 2 from Charan Chakrabarti, including the lands in the 1998 and by registered serial number 515932.
See, the appellate court has also not written it clearly. So you explain?
Dated 29.
There is no clarity in the language. In the trial court, they have just copy pasted it. So, unless you satisfy us on the relevance of these documents, they are absolutely immaterial. What is the relevance of these documents? Are you for the respondent? State? बताइए, इनको तो कुछ नहीं पता, आप बताइए. Any private respondent is also there.
Private respondent, we contest WS private respondent has filed.
और आपने क्या किया? आप राजा हैं?
जमीन तो वही नहीं कह रहा था.
File it appears that WS
क्या कहानी है?
अपीलेट कोर्ट का जजमेंट एक पैराग्राफ पढ़ने सारा कहानी क्लियर होता है.
हाँ बताइए, कौन सा फाइल?
लगता है कि प्रोप्राइटरी इंटरेस्ट परचेज है, जैसा फेवर की से पता लगा, लेकिन है नहीं लगता एग्जिबिट नहीं किया.
पेज 40 का लास्ट पैराग्राफ.
पढ़ी?
From perusal of deed dated 10/12/1985 by virtue of which son of Pribhang Chakrabarti has sold the land to Kailash Singh, it appears that Pribhang Chakrabarti and others may tenure holder of land मौजूद हुआ था. He has indemnity right in the suit land. It further appears in the description of the land that actually खाता number 58 has been stated in the schedule of the deed instead of खाता number 80. No permission was sought from the deputy commissioner for selling the land operating to खाता number 58. ये सूट में भी खाता नंबर गलत लिखे थे, अब परमिशन लिए थे खाता नंबर 58 प्लॉट नंबर 423 for execution of rectification deed. No such permission was sought. Rectification deed is Exhibit 3. Exhibit 6 series of order passed by settlement case against defendant number 1, where the revenue courts have refused to settle the land in his name after the plaintiff has filed objection and report of Halka Kramchari as revenue officer wanted to ascertain whether the land was actual government land or not. Next of the order dated passed in PPLE case number 7, it appears that removal of encroachment of Vishnu Matto and by interim order Vishnu Matto was ordered to remove the encroachment. यहाँ से मेन from the aforesaid oral and documentary evidence available on the record, it is evident that Pribhang Chakrabarti had purchased indemnity right of plot number 423, and after his death, his son Pashupati Chakrabarti had filed return at the time of abolition of Jamamandi name for 454 decimal of land out of 1.6 acre of land. 54 of land का इनका रहती लैंड है, बाकी स्टेट ऑफ गवर्नमेंट में बेस्ट हो. He subsequently sold 54 decimal of land to Ramayan Trivedi. It further appears that on the remaining land, Vishnu Matto had imposed upon the white order passed in PPLE case number, he was ordered to remove the encroachment. 54 डेसिमल का अतिरिक्त जो जमीन बचा था उसमें ये विष्णु मत्तो इन्क्रोच किए थे, जिसमें ऑर्डर हुआ था इन्क्रोचमेंट रिमूव करने के लिए. and it further appears that after removal of encroachment, the state government had settled portion of subland to Basing Turi. Basing Turi को already settled हो गया, बाकी जो जमीन बचा था. It is admitted case of the plaintiff and the defendant that Basing Turin has land adjacent to the suit land. It is also been admitted by the witness of the plaintiff that Jagannath Ram, private defendant was in possession of the suit land. Had son of the Bhang Chakravarti took Kailash Singh, the plaintiff, in possession of the suit land after his purchase, there would have been no occasion for the state government to get the encroachment removed from the by instituting the daily case, and furthermore, there would have been no occasion for settling the portion of land of lot number 423 to Basing Puri. So it can be safely concluded that Kailash Singh never came in possession of the suit land after purchase from son of the Bhang Chakravarti. It further appears that permission for the DC Dharbar was obtained for purchase of different land, Khata number 58. And subsequently, by rectification, it was corrected so as to show that Kailash Singh had purchased the suit. In view of the aforesaid circumstances, I am of the opinion that son of the Bhang Chakravarti had no right title in valid title and interest over the suit land to transfer the same to Kailash Singh. As such, he had no valid right title over the suit land. As already stated, he is not in possession of the suit land. This issue is decided against the plan. And we have substantial question of claim whether non-consideration of Exhibit C series by the trial court as well as appellate court comes to the root of the case, and as Exhibit C series has not been considered by the court below, ये देखा जाए लॉर्ड साहब Exhibit C कंसिडर किया गया है. Exhibit C देखिए.
Exhibit C head. Exhibit 6.
ये बंदोबस्ती सेटलमेंट केस का ऑर्डर है, जिसका पेज नंबर 11 पढ़ते हैं.
Exhibit 6.
पेज 11.
Exhibit 6 पढ़ रहे हैं.
हाँ.
तीन ही पेजेस.
Exhibit E लिखो. पर्सनल जमीन पर आपत्ति श्री पशुपति चक्रवर्ती को बार बार नोटिस दिए जाने के बाद भी उपस्थित नहीं है. और ना कोई कागज दिख रहा है, कोई डॉक्यूमेंट इनके वेंडर के पास नहीं था. ना एम फॉर्म केवल 54 डिसमिल के लिए था, बाकी तो स्टेट गवर्नमेंट बेस्ड हो गई थी. ना इनका जमाबंदी था, ना म्यूटेशन.
तो इनका कहना है कि Exhibit 6 सीरीज नहीं कंसिडर की.
Exhibit कंसिडर वही तो करना है. सेटलमेंट केस में कोई कागज नहीं दिखाता है, बार बार नोटिस दिया गया है के बावजूद उपस्थित नहीं हुए, ना ही कोई कागजात दिखाए.
कितने दिन के बीच हुआ है Exhibit 6?
ये हुआ है
कौन पार्टी है इसमें?
इसमें एक केस फाइल किया गया था डिफेंडेंट नंबर 1 के द्वारा सेटलमेंट के लिए, दूसरा केस इनके द्वारा फाइल किया गया था एमपी केस कैलाश सिंह वर्सेस जगन्नाथ, एमपी केस नंबर 2146। हथियार में लगा हुआ कंटिन्यूस हथियार रहती कॉलम में गैर आबाद
नहीं, आप उनको जरा ये देखिए तो डिफेंडेंट नंबर 1 का एविडेंस है और जो प्लेंटिफ का एविडेंस है, पढ़िए इंटरनल पेज 4 ऑफ द एपलेट कोड। Exhibit 6 as CC of order passing settlement case number 5 written bracket Roman 3 of 88-89। ठीक है? ये which is same as Exhibit C, same है कि अलग अलग है? Exhibit 6 is same as Exhibit C।
एग्जिबिट सी 6 और
Exhibit C
अलग अलग।
Exhibit C देखिए,
सर्टिफाइड फॉर ऑर्डर पास्ट इन सेटलमेंट केस
सेम है कि अलग है?
अलग।
नहीं, Exhibit C देखिए, ये नहीं समझ आ रहा आपको?
सेम है,
सेम है कि अलग है?
सेम
है। Exhibit C is same as Exhibit 6। और भी देखिए, certified copy of order passed in miscellaneous revenue case appeal number such and such। इसमें अपील 110 भी नहीं, ये वाला 179 भी नहीं है, ये वाला है CC of order of commissioner 972,000। एक एग्जिबिट ए है ना,
ये सारा एग्जिबिट कंसीडर किया गया, तो आप
एक सेकेंड, एग्जिबिट 6/D is exhibit A, correct? कुछ तो कॉमन एग्जिबिट्स हैं, exhibit 6/D, exhibit 6, these are common exhibits of both the parties।
कॉमन एग्जिबिट अब सब इनके अगेंस्ट सारा होता है,
ये सारे ऑर्डर्स इनके अगेंस्ट में हैं।
सारे वो कंसीडर भी किया गया नॉट
कंसिडरेशन दिखाइए ना,
कंसीडरेशन सबसे
पहले तो ये दिखाइए कि ये सारे ऑर्डर्स इनके अगेंस्ट में हैं, तो कंसीडर करके इनको क्या फेवर में, इनको कोई फायदा नहीं होगा उससे। एग्जिबिट 6 बताइए किसके अगेंस्ट में? एग्जिबिट 6 कौन पार्टी है एग्जिबिट 6 में? एग्जिबिट 6 जो है इज सेम एज एग्जिबिट सी। एग्जिबिट सी का कंसिडरेशन दिखा दीजिए तो एग्जिबिट 6 का कंसिडरेशन हो जाएगा, है ना? बताइए एग्जिबिट सी का कंसिडरेशन दिखाइए।
एग्जिबिट सी है आगे तक एग्जिबिट 6 देखा जाएगा उसमें यहाँ लास्ट प्रश्नगत जमीन गैर आबाद मालिक खास है, आवेदक जाति के समान है और यहाँ के मूल निवासी है। ये वाला केस सेटलमेंट केस डिसमिस हो गया था इनके अगेंस्ट, इनके अपीलेट कोर्ट जजमेंट में आया।
कहाँ लिखा हुआ है?
ये अपीलेट कोर्ट जजमेंट में पढ़े।
खाता नंबर 18 से रिलेटेड है ना, खाता नंबर 18 प्लॉट नंबर 423।
हाँ 423 यही सूट लेंगे,
ये सूट एक और खाता नंबर 18 है सूट लाइन।
हाँ खाता नंबर 58 में फाइल किए थे, बाद में करेक्शन किए। 423 खाता नंबर 18 यही सूट लेंगे।
ये सूट लाइन है, ठीक है। एरिया 45 डेसिमल। ये किसने फाइल किया था? जगन्नाथ राम।
ये कैलाश सिंह ने फाइल किया था।
जगन्नाथ राम। जगन्नाथ राम। Who is जगन्नाथ राम?
ये तो लिखा हुआ है बगल में लिखा कैलाश सिंह वर्सेस जगन्नाथ राम। कैलाश सिंह का फाइल किया ऊपर में साइड में लिखा कैलाश सिंह वर्सेस जगन्नाथ।
आपके नहीं, हम अपना रिकॉर्ड से देखेंगे ना। दिखाइए कहाँ लिखा हुआ है, दिखाइए।
एग्जिबिट सी है,
एग्जिबिट सी में है तो एग्जिबिट 6 में, क्योंकि सारा का सारा क्वेश्चन ऑफ लॉ एग्जिबिट 6 से बना है ना। एग्जिबिट सी सेम एज एग्जिबिट 6। Exhibit C is same as Exhibit 6.
सेम वही होगा। ये कैलाश सिंह के बारे में सेटलमेंट जैसे
Yes, madam. Is Exhibit 6 same as Exhibit C?
सेम सेम है। जगन्नाथ राम के द्वारा फाइल किया गया था, प्लेंटिफ के द्वारा ऑब्जेक्शन दिया गया।
देखिए हम आपको एग्जिबिट 6 मार्क करके दे रहे हैं और एग्जिबिट सी भी मार्क करके दे रहे हैं, ठीक है। सेम तो नहीं लग रहा हमको, कहाँ से बोल रहे हैं? ऑर्डर में सेम दिख रहा है लेकिन सेम जैसा तो नहीं लग रहा है। per the appellate court order, Exhibit 3 is same as Exhibit C. देखिए, Exhibit C and Exhibit 3. They are not same. आपसे पूछ रहे आप तो हाँ बोल दिए, सेम है. बताइए सेम दिख रहा आपको?
केस नंबर दोनों का एक ही है, ऑर्डर का कॉपी आगे पीछे, मतलब इनका अलग ऑर्डर कॉपी लगा होता है.
सेम नहीं है ना?
नहीं, केस नंबर से जमीन बंदोबस्ती
एक केस में 2 ऑर्डर हो जाएगा तो सेम
अलग अलग ऑर्डर नहीं हुआ है, मतलब इंटायर ऑर्डर कुछ पार्टी लगाए होंगे, कुछ
पार्ट बताइए कौन सा पार्ट?
ये ऑर्डर लगाए हैं 6/4/91 का, तो एग्जिबिट सी में हम
ये ऑर्डर लगाए हैं कौन सा?
6/4/91
6/4/91.
हम लोग का लगा हुआ 31 से 89 से लेके 3/7/90 तक.
3/7/90. इन्हीं का ना ऑर्डर लास्ट का है 6/4/99.
हाँ, इनका लास्ट ऑर्डर है, इनके केवल ऑर्डर नहीं वर्ड है. द्वितीय पक्ष
एग्जिबिट 6 में कौन कौन पार्टी है?
रिपोर्ट है, सी सिर्फ रिपोर्ट है.
एग्जिबिट सी से रिपोर्ट है,
हाँ,
लेकिन
report.
एग्जिबिट 6 तो फाइनल ऑर्डर
हाँ,
है.
वही मेन ऑर्डर.
वही मेन ऑर्डर है एग्जिबिट 6. ठीक है. एग्जिबिट 6 किसके किसके बीच में है?
एग्जिबिट से कैलाश सिंह, जगन्नाथ राव और कैलाश, डिफेंडेंट नंबर 1 और प्लेंटिफ.
प्लेंटिफ कौन है?
प्लेंटिफ है कैलाश सिंह, जो अभी अपीलांट है.
We are the objectors. This settlement case was filed by them against the state, against the revenue authority, and we are the objectors. We have filed objection in this case.
You are Kailash Singh?
Yes, ma'am.
You were the defendant or the plaintiff?
We had just filed objection.
You were the defendant or the plaintiff?
Plaintiff
in the
this
suit.
Yes,
In the
ma'am.
suit, right? You filed objection.
Yes, ma'am.
Objection in connection with?
Is saying that this would not be settled in their name because I had a sale deal.
Okay. It could not be settled. When did you file your objection? What was the objection number? It was the order passed in the objection.
Yes, ma'am.
Objection was rejected or allowed?
And now that's why the settlement was rejected. Their settlement case was rejected.
ये लास्ट पैराग्राफ पढ़ लें. जिस भूमि को आवेदक के साथ आवेदक जगन्नाथ राम डिफेंडेंट नंबर 1 के साथ बंदोबस्ती करने का प्रस्ताव है, उसमें सरकारी होने में भी संदेह है. आपत्तिकर्ता द्वारा 1939 और 1933 का निबंधित दलील प्रस्तुत या जाना या विचार करने के लिए बयान करता है कि जमीन सरकारी है या रैयती हल्का कर्मचारी के परिवर्तन से स्पष्ट है कि इसका लगान कार्य भी किया गया है. ऐसी स्थिति में सुनिश्चित किया जाना चाहिए कि बंदोबस्ती के लिए प्रस्तावित जमीन सरकारी जमीन है, उपयुक्त सरकारी जमीन है. उपयुक्त तत्वों के आधार पर आवेदक के साथ प्रस्तावित जमीन के बंदोबस्ती का कोई औचित्य नहीं. मेरा सेटलमेंट केस
Settlement case was dismissed. Of defendant number 1. Defendant number 1?
डिपेंडेंट.
क्या नाम है? जगदीश राम.
और ये कंक्लूजन है कि सरकार
क्या नाम है? जगदीश राम.
जगन्नाथ राम. फाइनली कंक्लूजन है कि जमीन सरकारी जमीन. तो ये तो कंसिडर किया ही गया ना सर, कंसिडर एग्जिबिट।
Just a moment. The settlement case was initiated and his claim of settlement was rejected. Jagannath Rao.
जगन्नाथ
By holding that this is government land.
इसमें कोई टाइटल क्लेम नहीं कर रहे, मेरा तो पोजीशन के पोजीशन में है, ये हम पार्टी इसलिए हैं क्योंकि ये हमको मेरे खिलाफ सूट फाइल, अदरवाइज मेरा
तो सेटलमेंट तो आपके फेवर में नहीं डिसाइड हुआ।
सेटलमेंट डिसाइड नहीं हुआ, आपको टाइटल भी क्लेम नहीं कर रहे।
टाइटल भी क्लेम नहीं, क्या क्लेम?
सरकारी जमीन है तो हम टाइटल क्लेम कैसे करेंगे?
तो आप क्या क्लेम कर रहे हैं?
हम तो इसलिए अपियर कर रहे हैं कि हमको पार्टी बना दिया, मेरे खिलाफ जो है हम पोजीशन में हैं तो रिकवरी पोजीशन का भी एफआईआर कर दिए हैं, इसलिए हमको पार्टी बनाया।
हाँ, तो इसका ये कहना है कि ये जो आप पोजीशन में है तो यहाँ पर तो ये दिस हैज बीन डिक्लेयर्ड टू बी अ गवर्नमेंट लैंड, राइट? इट हैज नॉट बीन डिक्लेयर्ड टू बी देयर लैंड, करेक्ट?
यस।
ठीक है। You see, madam, this exhibit 6, by virtue of exhibit 6, it has not been declared that the property belongs to you. It has been declared that it is a government land. How do you take advantage of this as a plaintiff? Merely because the settlement case was not decided in his favor, does it give you any entitlement?
Out of the entire area for 52 decimals of land, there was permission given, my lordship.
What is your title?
The suit, the title deed, my lordship, the sale deed.
You were claiming title on the basis of a settlement.
No, my lordship, my vendors.
One and the same thing, right? And it was declared that the land is a government land in this proceeding. How do you derive any advantage out of this? It is okay. It is not in the favor of the objector, but it is not even in your favor, because once you say that these documents were not considered, so we have to consider it. How does Exhibit 6 help you? How does it help you? उसके बाद 6/A is the appellate order arising out of the same. That was also in whose favor?
It was not in their favor.
Was it in your favor? No. Exhibit 6/B is what?
This was an MP case filed, my lordship.
By whom?
Two are there, my lordship. One has been filed by them and one has been filed by us.
Exhibit 6/C is the order of two cases.
No, my lordship, we have exhibited only one and they have exhibited one.
Which is their exhibit?
पेज 25 एग्जिबिट सी का डिस्कशन है, पेज 25 ट्रायल प्रोजेक्ट।
आप एग्जिबिट 6 का डिस्कशन दिखा दीजिए, इनका केस हम
हाँ वही है, एग्जिबिट सी और एग्जिबिट 6 तो सब एक ही।
कहाँ सेम नहीं है ना? आप तो बोले ना दो अलग अलग डेट का ऑर्डर शीट है, कैसे आप सेम बोल रहे हैं? Yes, 6 series, we are looking at each one of them. 6 series is 6 to 6/D, that's it, isn't it? So this is 6 and 6/D is the original order and the appellate order, right? 6/B is CC of MP case number 110. What was this MP case?
My lordship, two cases under 144 CRPC proceedings were initiated, my lordship. First, they had initiated it and then we had also filed it and the earlier order was vacated, my lordship.
What was your case number?
My lordship, there are two two MP cases, MP case number 2146 of 92, which they have filed, and this MP case number 110 of 1994, which we have filed.
So Exhibit B and Exhibit 6 by B are related documents.
Yes,
It has been jointly taken up, separately decided.
my lordship, two separate cases, my lordship.
So in CC of MP case number 110 of 94, which was filed by you,
Yes, my lordship.
what happened? The property was declared to be your property. The property was declared to be your property.
No, my lordship, in this 144 case, no declaration of
Possession?
title, only possession, and the earlier order was vacated, my lordship.
Earlier order of
Earlier order under 144 CRPC was vacated, my lordship, in respect to the suit property.
who was ultimately found in possession? Your vendor was this Tribhanga Chakravarti. He
His
declared
three
only
sons.
his 3 sons. He declared only 54 decimal of land.
Yes.
Does it include this property? This 54 decimal of land.
नहीं वो तो ऑलरेडी रामायण पूरी को बेच दी है तो आया
We have sold it to Ramayana Trivedi.
54 decimal.
हाँ 50
Deed number. So you have sold 54 decimal of land to Ramayana.
और बाकी जमीन भेस्ट कर दिया स्टेट
So सूट लैंड कौन सा है? 54 decimal का पार्ट है?
नहीं 54 डिसमिल का पार्ट नहीं है ये जो भेस्ट कर गया है
उसका
state
part.
उसका
Yes, madam. You are claiming by virtue of this Tribhanga Chakravarti, his M form has been considered. As per M form, it was only 54 decimal of land, which he claimed, on which he claimed royalty title. Correct? This entire 54 decimal has already been sold by you, and he had his descendants had sold this property to you, and the entire 54 decimal has already been sold by you. So, on what basis are you claiming rest of the land? And what is the use of reliance upon this six series? For what? Please appreciate. For what purpose are you relying exhibit 6 series?
This MP case also in the trial court's order also, their MP case has been considered, but our MP case has not been considered.
You see, any document which you file, even if not considered, the question of its relevance comes only if it is material. So I want to know from you, what is the relevance of exhibit 6 series?
While considering their MP case, it has been held that in their MP case they were found in possession. But in our MP case, the earlier this thing was changed.
Who was found in possession in your MP case?
We were only found in possession.
Which is that exhibit?
And usually that is only 6 by B violation.
Depending on one has been. Exhibit B में आया है.
Exhibit 6 by B, right? And then this is corresponding to exhibit B,
Yes,
right?
exhibit B.
Exhibit B किसके फेवर में?
मेरे
पोजीशन आपका है.
हाँ पोजीशन.
और exhibit 6 by B?
वो भी मेरा पोजीशन हर कोर्ट.
Yes. Be it this whatever be the court, he says that throughout he was found in possession of the property. How does it help?
Ladyship, on that same sale deed, the first sale deed, this Tribhanga Chakravarti, where he sold his 3 sons, sold it. The total area was 1.6 acres, my ladyship. So that out of that same sale deed, I have sold 0.45 acres. To this
0.5.
Yes, my ladyship.
So
To this
whatever
Ramayana
declaration
Trivedi.
was made by your vendor has been sold by you.
Yes, my ladyship.
So what is left with you?
My ladyship, the rest of the portion, 1.6 minus
So why?
0.54.
So how will you get title over that? Because your vendor has given return only to the extent of 0.54 decimal of land, claiming the royalty title. Your vendor did not claim the entire property. Then how does this exhibit series help you? It doesn't help you in any manner. Pratham Paksh Kailash Prasad Singh, correct? And this has been Possession has been found in favor of Jagannath Ram. This exhibit exhibit B, डेट बताइए exhibit B का 15/12/92 92. This is MP case number 2146 of 92. Possession of Jagannath Ram is defendant number 1. Defendant number 1 found. This was between Kailash, plaintiff and defendant number 1. This is defendant number 1. What about exhibit 6/B? This is LP case number 110 of 94. Who are the parties? What is the date of the order? Exhibit 6/B is this is 5494. This is again plaintiff versus defendant number 1, right? It only says that no effective order can be passed. ये पक्ष ने अपने हक को नकारने के साथ साथ no clear finding has been recorded. What is the use of this document? Just tell us, why do you want to use this document? It does not have any clear finding. Does it have any clear finding in your paper? B and exhibit 6 by B. Resolve. It does not help either of you. The court itself says that कुछ स्पष्ट नहीं होती है situation. Now exhibit 6. What is exhibit 6? Come to exhibit 6. This is dated 6/4. 6 is dated 6/4/91. Right? Jagannath Ram is there.
His settlement case was.
He claimed settlement.
Yes.
Okay. Defendant number 1 claimed settlement. Plaintiff objected. Correct? So, what is the conclusion?
There it has been held that as it is.
It cannot be settled with them. It cannot be settled with defendant number 1. Does it declare your title?
After all this also, in the revisional survey,
He says it has to be found out whether it is a government land or not. It doesn't help you. Right? Not in your favor. Merely because his settlement is rejected, it is not in your favor. You just tell us how do you want to take advantage of this document?
after this subsequently there was one in the revisional survey also that came.
Madam, we are only confining ourselves to the question of law.
6 by C.
Now we have seen 6. We have to see 6 by C. Exhibit 6 by C. Yes, what is exhibit 6 by C?
Subsequently also when the revisional survey came out, the appellant's name had only been recorded Malaysia with regard to this property which was allegedly
First let us finish 6 by 8. We'll come to 6 by 8. What is 6 by 8? This is the appellate order. Appellate order, right? His appeal was dismissed. Premature. Just come to this. No clear picture has been given, even in this. Appeal was dismissed.
The revision was also dismissed.
Appeal dismissed. What is exhibit? This is filed by defendant number 1, correct? Where is the order of revision exhibit number?
that is Exhibit A. Revision is Exhibit A of the defendant violation.
Revision is this is Exhibit 6/D. Same. 6/D and Exhibit A are one and the same document. Is that correct? Exhibit 6/C, Exhibit 6/D. It says that just a moment, 6/D. We are in Exhibit 6/D. Exhibit 6/D, the revision was again dismissed against, right? Exhibit 6/D and Exhibit A are the same document, correct? So, RC, revision dismissed, correct? The revisional authority says that neither the petitioner nor the OP have contested the contention and hence there is no reason to believe this contention. It is, if a title suit is pending in civil court between the same parties and for the same land, so no useful purpose will be. So does it help you in proving your title? No, it doesn't, right? So exhibit, now which exhibit is left? Exhibit 6/C is left, correct? What happened in Exhibit 6/C?
After this,
What is Exhibit 6/C?
my relation R name was there in the revisional survey violation. Against that, they have filed an application under Section 89 of the CNT Act.
Who filed? Okay.
The defendant for correction of the entry made in the revisional survey violation.
Exhibit 6/C, defendant number 1 filed application for correction, correct?
The entry made in revisional survey
Under Section 89. Okay. What happened? Title suit चल रहा है. No, that is dismissed. Title suit चल रहा है. What is the ground of dismissal? There is a pending title suit.
94 as the title suit is pending therefore.
Yes. So does it help you? Just tell us in any one of the documents does it help you in proving your title? So these are absolutely immaterial documents. It doesn't take you anywhere. 89 proceedings also says that title suit is pending, and ultimately these other proceedings also take you to the same thing, that the title suit is pending. So how does non-consideration of Exhibit 6 series has any bearing in this matter? बताइए, है कोई bearing? एक एक डॉक्यूमेंट पूरा पढ़ लिया मैडम, सेकेंड अपील में इतना काम भी नहीं होता पढ़ने में. Absolutely unnecessary. और कुछ बोलना है?
Yes, sir, plenty. As a list on the basis of purchase from the ex-landlord.
इसको सेकेंड हाफ में सुनेंगे, डेट
हाँ,
बढ़ गया. I will sit slightly late.
इन्होंने कोई ना फॉर्म रिकॉर्ड पर लाया है ना रेंट रिसीट लाया है.
नहीं तो फाइंडिंग में तो आ ही रहा है ना, एन फॉर्म के अनुसार ओनली 54 डिसमिल बेचा।
अब बड़े वो तो आ रहा है लेकिन एम फॉर्म लाया भी नहीं, वो भी एम फॉर्म माने रिकॉर्ड पर नहीं है।
एन फॉर्म एग्जिबिट भी नहीं।
नहीं, अन रेंट रिसीट है कुछ इनका।
सेकंड हाफ में आई विल सिट थोड़ा सा, आई हैव टू गो समवेयर, सो थोड़ा सा लेट होगा, मे बी 2:45।